Hello everybody, this is your Professor Alex Fawcett TVE course, and I'm very excited to bring you another one of our computer electronics series. This one's dealing with copyright issues on YouTube. And you know, those of us that use YouTube a lot, and I'm very excited about YouTube, it's a wonderful thing, and it allows you to educate and learn and see things that you never would see on regular television. And it's a great thing, and those of us that put a lot of videos on YouTube often come up with this little notice that says we're using someone else's intellectual property. And so that's a serious concern when that happens. You know, and if you have that happen, you need to address that problem, and there's a procedure that you have to follow with YouTube to take care of that notice. And so I'm assuming that you're not using someone else's intellectual property. Now that's the first rule. If you're uploading something to YouTube, it needs to be your property. You do not have, it's not right and it's not legal to use the intellectual property that belongs to someone else. And especially without their written permission, you know, so you have to be very careful with that. It's like, would you go next door and drive off with your neighbor's automobile? It's the same thing, you know, when someone works hard to make some intellectual property, it's not right for someone else to just make a copy and start using it for whatever purposes they have without the permission of the owner of that property. And so you have to be very careful with that. Remember that all video content that's uploaded to YouTube is analyzed by an electronic content management system. This system compares uploaded content to that owned by rights management and collection companies. If there is a match between your uploaded content and the rights management company's file database, your upload video will become the property of the rights management company as far as monetization and advertising is concerned. There are many rights management companies, and they make a lot of money off the advertising that's on YouTube. And so they're there with an electronic system that looks at all the upload and compares it to their file database, and if there's a match, they will claim your video. So you don't want that to happen. Many of these companies that are the rights management companies are, a few examples are EMI Music Publishing, AdShare MG, the Harry Fox Agency, Warner Chappell, UMPG Publishing, SACEM, PRSCS, and Ngrooves, APM Music, Sony, ASCAP, BMI, UPPM, and AdRev. When you get a notice that one of these companies has claimed that you're using the intellectual property that they own, you need to follow a procedure. And this procedure will allow you to straighten the problem out. Now, it's important to straighten the problem out, especially if you were wanting to make money off your videos. If you have your video monetized, what will happen is when they claim this, the income that you would normally be making off these videos would then be going to the property rights company. And it's to your best interest to straighten that out. But at the same time, I want to tell you, don't use the property that belongs to someone else. Let's take a look at this procedure. When you have this notice come from YouTube, and let me get some pictures out here. You want to log onto your YouTube channel and click on the small triangle in the upper top left of the browser window. Several selections will appear. It looks like this, okay? So you're logged into your channel, and then you click up here, and then all of these selections will appear. You want to choose Video Manager, okay? Once you've selected Video Manager, then a selection of all your videos that you've uploaded will appear. And then once you get to that point, you want to locate, you want to go to this one. Over on the left side of your Video Manager is a Copyright Notices selection. You select that, and then you can go to a page that shows all your videos. All right? Now, once you get to that, you locate the video, and here's an example of one of mine that has the match to third-party content notification on it. So that means this particular video has this, and what this means is that's been claimed by a third party that says that I'm using their content. And so I have to figure out why they're saying that and deal with the situation, because I know on this particular video I didn't use anyone else's electronic or intellectual property. Okay, so once I click that, then I go to this page. Now what I see here on this page is a description of my video, and I can actually play the video here. And when I play the video, it will start playing at the point in time that the intellectual property company says that I'm using their property. And so it's playing here at almost the end of the video. And so when I start playing that, it starts playing some music that I put at the end of the show. Well, okay, and I looked at this and I see what they're claiming. They're saying that I use this song, which is a Gustav Holst classical music piece, and that says that that belongs to EMI Music Publishing. And what I did was I started researching this. Well, what I used on my video was this in fact, this song, but this particular song by Gustav Holst has been in public domain for many years. And so I didn't have to worry about the actual song, but you can get in trouble by using like an orchestra that is copyrighted, a symphony orchestra that's copyrighted their production of the song. What I did was I downloaded a copy from Skidmore College Orchestra that I used, and that was given as a free-to-use copy of this program that was allowed. You got allowed use in public domain, and I downloaded it from a site called museopen.com, which then gave me the ability to use this piece. But what they're doing here, because the sound of the piece that I used, which was in full public domain with permission to use, sounded just like this one that belonged to another orchestra, they went ahead and claimed it. Well, they made a mistake because I used something that was absolutely in public domain, but it sounded like something they owned, and so they claimed it. Now, what happened is, at this point, I have the selection. Do I acknowledge that I put their song on my video, or do I dispute it? Well, if I in fact use their property, about the only two things I should be able to do is acknowledge that I used their property or take my video off of YouTube. But in this case, I know I didn't use their property, so I'm going to click the dispute button. Okay? Now when I click the dispute button, then we come up with this page, which gives us a lot of selections. We have 1, 2, 3, 4, 5, 6, 7 choices, okay? The first one says, and I can select it, I own the CD or DVD or bought the song online. The second one is I'm not selling the video or making money from it. The third one is I gave credit in the video. The third one is the video is my original, or the fourth one is the video is my original content and I own all the rights to it. And the fifth one is I have license or written permission from the proper rights holders to use this material. The next one is my use of content meets the legal requirements for fair use or fair dealing under applicable copyright laws. And the next one is the copyright is in public domain or is not eligible for copyright protection. Well, okay, let's go over these specifically. Let me go down here and let's take a look at okay, let's look here. So the first one is I own a CD or DVD that I bought, and I bought the song online. Okay, well, that's really not an acceptable. That is not an acceptable dispute. Owning the CD or DVD or an online purchase does not give you the right to duplicate or sell or share this intellectual property. That CD is only for your use and your personal use, or maybe in playing in the house with a couple of friends or whatever, and that's the extent of it. So that is, when you check that box, you say, automatically that actually I don't own this property and the people that claim this on my video are right. The second selection, I gave credit in the video. This is also not an acceptable dispute because giving credit does not give you the right to duplicate, sell, or share the intellectual property that's in question. Okay? Now there's some cases where Creative Commons will allow you to download and use something they have as long as you give them attribution, which is basically saying, telling where it came from. It came from a Creative Contents originator. But that's only in that instance. And so you cannot use, if you say the second one, you know, that's also not a good choice. Okay? The other one that says I'm not selling the video or making any money from it is not acceptable either, because the fact you're not making money from it doesn't negate the fact that you're also using someone else's intellectual property. And so that is just the same as saying, yes, they own it and I made a mistake. Okay, this one. Okay, now the one here, the one that says, the video is my original content and I own all the rights to it. That is an acceptable answer if and only if no part of your video has any intellectual property that belongs to someone else. You could have an hour and a half of your own content and there's 2 seconds of somebody else's music, and then you have a problem. And so you have to be sure that every bit of the footage on this video has property or has content that you own the rights to. Even 1 second of someone else's content violates this agreement that you made with YouTube when you started the account. Okay, now this one here. I have license or written permission from the proper rights holder to use this material. That's an acceptable answer if and only if you have a written piece of paper or electronic document that shows that you have indeed and in fact been given permission and ownership of this video. And then the next one, my use of this content meets the legal requirements for fair use or fair dealing under applicable copyright laws. That's a very iffy selection. And you know, there's a lot, you need a couple lawyers to determine if you're really doing that or not. And so, you know, outside of having to go to a lawyer to get this really settled, this is probably not a very good selection, because you have to prove that in the instance of your use that you are not infringing on the copyrighted content because you're using it in a fair use situation or fair dealing situation. And that is a very iffy answer, so I'd be very careful with that. In most cases, you probably wouldn't get that accepted by YouTube. And then the last one is the content is in the public domain or is not eligible for copyright protection. Now you can get a lot of public domain footage and use in your videos, but you have to be absolutely sure that this is in public domain. You have to look it up and you have to see that in fact the video you're using is public domain. For instance, sometimes you can go to Creative Commons and they'll have a lot of things that you can reuse that is eligible for use, and it's not necessarily public domain, but you're allowed to use. You can find works that are over, I guess it's, you know, somewhere around 50 years old, but you have to find a statement on this piece of intellectual property that says it is in public domain, and you need to be able to show that to be able to use this selection. Okay? So once you've chose a selection, what I did with my particular video is, because it was in public domain, I checked the public domain box on the selections page, and I came up to here and I said, let me go to this page here, actually this page here. I said, I'm disputing this, and the item I'm disputing is this particular piece of music, The Planets Opus 32, and it's EMI said they owned it. Well, what I said was, the reason for this dispute is this video contains the material at issue, but the material is in the public domain and is not eligible for copyright protection. Now what I'm saying here is that you know, yes, it's the same song, but the song itself is in public domain, and EMI is claiming it on behalf of, say, another orchestra. I'm using an orchestra that gave me permission to use it. So what I said was, the planets, and I just stated what the song was, and the person who wrote the song, and who performed the song, which was the Skidmore College Orchestra, and where I got the song, which was the Muse Open project at museopen.org, which has a statement that this is in public domain and I can use their property. And it has been identified as being free of known restrictions under copyright law, including all related and neighboring rights. So I typed that in that specifically. Then I checked the good faith paragraph here, and I typed my name. You have to be very careful, because you do not want to enter your name and all of this on here unless you are being very truthful and accurate. And then I clicked on continue. Okay, when I clicked on continue, I went to this page, and then it took what I typed and it put it here. Okay, and it explained that I have this item, this particular work. It's definitely in public domain. I showed where I got it from. I showed what I did with it, and then I went and I said, I'm sure this content is ineligible for copyright protection, and I continued. And when I did that, then it came up with this one. This is the final page. And it went over it. It then said the reason for dispute. It then put in my explanation. Then it put in my good faith statement, my signature, and then I submitted the dispute. Okay? And when I submitted the dispute, then I had this verification saying my claim had been submitted. Now, it may take a month or two to get this taken care of, and the sad thing about this is that during this time, you know, the company like Harry Fox Agency or whoever it might be is making money off of the advertising on the video, and I'm not, and I do not get reimbursed for that period of time when this is in limbo. So that's just the way it is. Now, there's one thing that you don't see in the selection box is well, the missing selection is on the pages where the content management system made an incorrect identification of an intellectual property, and this seems to be happening a lot more than it used to. I've got an example here. This is for a video that I have on YouTube now, and it's about to hit 200,000 views. And when I put this on YouTube, it was again the same issue with this particular song that was in public domain. I had absolute proof it was in public domain, and so when I first put it up, it was claimed by EMI Publishing. When they saw where it came from and they analyzed what I said, they released the claim. And then AdShare came in and claimed it, and then I had to go through the same process again, and they released the claim. And then on down here, the same thing happened with AdShare again, and I had to show them again, and they released it. And then also APM Music came in and put a claim on it, and I had to show them, and they released the claim. So this was a lot of time that my advertising revenue off of this particular video wasn't coming in, because all these people were tag teaming the claims on this video. Well, then there came something really strange. They said that I was using a song called Never on a Sunday. Well, that's a song out of a 1960s Italian movie, and I definitely did not use that song on my video. But what happened is this Gustav Holst piece has 3 beats that's exactly the same as Never on a Sunday. So the automated system that looks at all this or listens to all this identified that I was using this song. Well, I don't have a checkbox when I dispute that says, you know, the machine made a mistake when it was looking at my video, so you have to make your best choice, and I did. And so on behalf of Never on a Sunday, Harry Fox Agency, Warner Chappell, UMPG, SACEM, PRSCS, and EMI claimed that I was using this song, which was in no way on this video at any time. It's just the misidentification. And so I'm having to wait, about a month and a half for all this to trickle through the system. Warner Chappell and UMPG have had to release the claim, and of course all these other agencies will have to release the claim too when they look at it, but it takes time. And of course this is why you want to be really careful when you put songs on your video. In retrospect, I'm wondering if I should even be using the whole piece, even though it is fully in public domain. It still sounds like stuff that they own, music that they own, so it causes me a lot of issues. So this is an example, but eventually it'll trickle through the system, okay? And so what would you say to them when you write it up? There's two types of statements you can make, and I'm going to give you some examples. For instance, if it's in public domain, you need to state the name of the intellectual property, who performed it, who wrote it, and then say it has been identified as being free of known restrictions under copyright law, including all related and neighboring rights. Well, you need to point out where you got this piece from, and you need to find a statement that was issued with the property showing that it is in fact a public domain piece, because you need to justify that when you write up your explanation for the people at YouTube. And then, you remember, YouTube isn't really doing this. This is the thing where the copyright holders are going through these agencies to make sure they get income off of people that are sharing their work, or work with people that are using their work without permission. Now, another example is if I have a license, I'm using a work, but I have a license or written permission to use that, then you need to say something like, I have worldwide rights for use of, and you state the intellectual property, the song, the video, whatever it is, and you state who the rights holder is or the agency is, and you give their name and address, and you state specifically that they gave you the rights to use this, and put in the details. And that's a good way to respond for if you actually are if you have the rights to use a piece and they're claiming it on YouTube. So you need to have all that information. And so those are the issues you need to work through when you're doing this. But at any rate, I just wanted to say, you just need to keep in mind you can't use someone else's intellectual property on YouTube. They'll get you, and rightfully so, because when you make something that belongs to you, you don't want people just up and using it. And so that's something you shouldn't be doing. But if there's a mistake, if there's and I've showed you a couple of legitimate reasons why this problem could happen and how to deal with them. I appreciate you taking time to watch this video, and I hope it helps you. And I'll see you in the next TVE course. Thank you so much.